Phil, and as always with me, my trusty co-host, the best and fastest researcher in the West, Camille. We took a week off. Don't freak out, everybody. I started a new job last week. Wife also started a new job. Schedules were hectic, and we were just like, you know what? Let's just take a break this week. So don't worry, we're going to be back on schedule. Everything's going to be fine. We'll be back to our uh, weekly Thursday nights, 6 o'clock, YouTube and Rumble. As always, we're starting to line up candidates. People are starting to line up for the summer. A busy election year coming up, so probably not many chances for breaks coming up. But Camille, how are you doing? Welcome back after a week off.
I know I'm confused. Where am I? How do I speak? Where do I look? I don't know. No, I'm good. How are you?
I'm good. I know it's funny because we're so used to doing this weekly that just taking 1 week off feels like we took like a month off. And I don't know how other podcasters who take like 4 months off between podcasts actually do it and remember how to podcast after that. I mean, that's too much time. So but anyway, a couple announcements before we get started. First off, we got new merch. Got a couple new shirts, one designed by Camille, one designed by myself. One is called Local Elections Matter. Should I just show the people so that they
Just
can
show the
get an
people.
idea?
Just show, but then describe it. Describe it for the audio listeners.
That's right, because
make it sound amazing.
Audio listeners,
they have to go check it out.
So they have to go check it out. You can find all of this if you go to californiaunderground.live. You can go there and click on store, and that's where you'll find it. Why can't? Oh, here it is. There we go. This is hot off the presses.
We need the applause sound effect.
Yep, applause sound effect. So this is Local Elections Matter. If you notice, yes, we did use the logo or the style of Black Lives Matter, but we think local elections matter, so that's why we put it in this style. And there's also another new one. This one was designed by
Wait, hold on. You are not selling it here, Phil.
Okay.
You got to talk about what options are available, what sizes are available. Are there different colors? Is it just the one? It's
in black. It only comes in black because that's the only way the logo makes sense, is if it's in black.
Okay.
It looks so it's one of those shirts that it tricks your eye because you look at it and go, wait a second, I've seen that logo before. Where did I see it? Oh, it's Black Lives Matter. But no, it's actually Local Elections Matter. We have it in a comfort tee for men and for women, and we also have a unisex classic pullover hoodie.
Okay.
The comfort tee is going for $23.99, so is the women's tee. And the pullover, I have one of the pullovers, the Elites Hate You. That's one of my favorites. It's actually really comfortable. And these comfort tees are actually really comfortable as well. My wife actually ordered one of the men's comfort tees, and she now wears it, and it's really comfortable. So she loves it. Now moving on to yours that you designed, and I swear we do have a podcast topic tonight. We're not just stuff. I like this one. California is worth fighting for. I really like the script. It's a nice color. I like the lettering. I like that it grabs your eye with the California, and this is worth fighting for. I also realized the California also is kind of like shaped like the state. It's kind of like that curvature of the state. I don't know if you meant to do that intentionally.
I did not mean to do that.
That one also comes in comfort tee for men, women, and it comes in a unisex premium pullover hoodie. So with that out of the way, go check it out, californiaunderground.live. That's our whole, you can go see our website. We have our Instagram feed. Everything's up there. Everything kind of just funnels, all the stuff we do funnels into that website. Next big announcement is we will be back podcasting live. We're going to be doing a 3-hour live stream at the California GOP convention coming up on the 18th, Saturday the 18th, up in San Francisco. Yes, we're flying all the way to San Francisco to do a live stream. 3 hours like we did last time. We're lining up candidates. Also, candidates like to just stop by. So we'll be streaming that one all over the place. We'll be streaming it on Instagram Live, I guess Twitter, YouTube, Rumble, all these places. So yeah, that's basically it. And if you're going to convention, make sure you stop by. We'll be in the exhibitors table and you can swing by and say hi.
And if you're a candidate or current politician, stop by. Contact us. We want to talk to you.
Yes, absolutely. If you want to email us, the email is californiaunderground@protonmail.com. Okay. Enough of the business out of the way. This is
I
what
feel
happens
like
when you
we're at
take a week off.
church.
You have to catch up.
I don't know if your church does announcements. There's like all the upcoming things, and it's like, okay, now we're going to take an
Yeah.
offering. So if anyone wants to,
Ours does the announcements ours does the announcements before mass starts. It's actually pretty funny. We have two different priests who run mass. It depends on the priest. And again, after this is over, I swear there's actually something we're going to talk about tonight. We're not just sitting here rambling. There's two different priests. One's really like chill and laid back. He's just like whatever. And one is very, very strict. And he will like tell the readers like, okay, 8:57, I want you to do announcements. I don't care if the band hasn't done their pre-mass song. Like 8:57 is when we do announcements. If the band is late, I don't care. Go over them. So it's always funny that like announcements to him are you got to get the announcements done before mass. He doesn't want to be late. He doesn't want to be 2 minutes late to start mass. And that's what's happening now is where you have all these announcements and we're already 10 minutes into the episode. All the fans have already
now I need to
dropped
know
off.
if you
They're
guys do you take a tithe?
Oh yeah, we do offerings.
But at what point?
That's later though. That's before we have communion.
Okay. So in my church, we would like do announcements, and then that person would pray, and then we would take an offering. And so this is where I would be like, "Give us all your money."
Right. Yeah. After the announcements, it's give us all your money. Not in our church. It's here's the announcements. Now we're going to start, just like we're going to do with this podcast. All right. So tonight's episode is actually pretty jam-packed. Camille and I both did a lot of research on this, and we're going to do our best to like get through this, explain it the best way we can. The title of it is that the Supreme Court takes up homelessness. And what does that mean? Last week, there was a case that went up to the Supreme Court. And let me back up. When you go to the Supreme Court, you file these things called briefs with your arguments. We're going to read a little bit of the petitioner's brief, meaning the people who are arguing to overturn a case. And they go in, they have oral arguments in front of these 9 justices. And the 9 justices, it's kind of it's really interesting to watch if you're like a legal nerd, because the lawyer shows up, and this is how it happens at all appellate level courts. The lawyer shows up, they have all their points, they have all their arguments. A lot of it's memorized, because what will happen is you'll launch into your argument and you'll give your oral argument, and the justices can start peppering you with questions, whatever they want, for as long as they want. So literally you can just be up there being interrogated by 9 Supreme Court justices. And you're talking about 9 Supreme Court justices. These people went to the best schools. Obviously, they made it to the top of their field. Pretty harrowing. I wouldn't want to go argue in front of the Supreme Court. As interesting as that sounds, I'd probably be too afraid to do that. So they heard oral arguments on this case. It's called Grants Pass versus Johnson. And it involves encampments of homeless people. So have you ever walked around your local city and said, wow, look at all the encampments in that public park. Why do we let homeless people get away with camping in public places? I want to take my kids to the park to play baseball or go enjoy a lunch outside, or I don't know, to go to the playground or something like that. Have you ever looked at that and gone, why do they get away with this?
Not in my
That's
city.
an actual question. Not in your city. Your city.
Not in my city. There's other local cities for sure that have had major
plenty
issues.
Of cities, I'm sure. If you walk around, you go, well, why are there homeless encampments all over the place, and why can't they do anything about it?
There, but I am very proud of how my city has handled this.
You have the benefit of living in Orange County, where
we have that issue in Orange County. We do.
Yeah. I mean, all counties have it, but I just feel like Orange County handles a lot of California issues way better than like other counties. Yeah. San Diego might be second best in terms of coastal counties, but
my worst. Entire city council is all Republicans. I don't know if that plays into this at all, but just thought I'd throw that out there. So
it probably has something to do with it. So this case, Grants Pass versus Johnson was heard at the Supreme Court last week. They had oral arguments. So what that means is the attorneys for both sides went, they made arguments, and we'll get to like the background of this case in a little bit. I want to tell you like where this all came from. Back in 2018, there was a case called Martin v. City of Boise. And in that case, don't ask me how this happened. I assume nonprofits or sort of advocacy group. The city of Boise had anti-camping ordinances on the books. So you couldn't camp at public spaces. Police would come and fine you. And if you didn't leave, they'd keep fining you and maybe put you in jail. So a couple of homeless people somehow sued the city of Boise. And I imagine, it's probably a nonprofit or someone who did all this, because it went all the way up to the Ninth Circuit Court. And they sued saying that you can't criminalize us for being homeless because we have nowhere to go and because there's no shelters available to us. That was basically the argument. You can't criminalize us for being homeless. There's nowhere for us to go. What do you want us to do? And they argued, this was a unique argument, which is probably what the Supreme Court is going to decide, is that by criminalizing and punishing those who are homeless and camping out in public or sleeping out in public, it violates the Eighth Amendment. Pop quiz, what's the Eighth Amendment about?
See, now you're just trying to make me look stupid.
The Eighth Amendment is about cruel and unusual punishment.
Okay.
So their argument was basically, it's cruel and unusual punishment to criminalize us and fine us and possibly put us in jail because we're homeless and there's nowhere to go. Now, people probably are like, well, wait a second. Homeless people, there's always this talk about shelters. There's places for them to go. In this case, Martin v. Boise, this is the original case back in 2018. They talked about certain shelters that they had. They didn't include all the shelters, but we're not going to get into that. There were 3 private, nonprofit, religious affiliated shelters that were available. And they went on about like, okay, this is what you have to do. Here's the curfew. Here are the rules. You have to be sober. One of them was like, you can stay there for 17 days, but after 17 days, you have to enroll what they call their discipleship program, which is a faith-based program that you have to attend for 30 days, and then you get to stay longer. And then there was like this whole system about the city of Boise and the police were able to figure out like, were there shelter beds available? Was there space for them to go? So that way, if there was no shelter beds, the police could decide not to enforce this camping ban and not issue citations. Okay. So that's basically the lay of land of this original case.
And that case went to the Supreme Court?
No, this case only went to the Ninth Circuit.
Oh, you said that. Okay.
So let's back up why that has a big impact here on California. So federal courts are broken up into circuits. So there's districts and there's circuits. Like, for example, I'm in the Southern District of California. That's my federal district. There's state courts and there's federal courts. When you start a case, you end up in a district court. That's the first, what they call the court of first jurisdiction. You show up there, you do your case. If you don't like it, you can appeal it to a appellate court, and in federal court, it's a circuit court. There are 13 circuits in the United States. Fun fact, they are called circuits because back in the day when there's like 13 colonies and they didn't have a lot of federal judges, literally like federal judges would travel like around these different states and decide cases like one by one. So they called them like, okay, you have this circuit and this is your circuit. So the Ninth Circuit encompasses all of the West Coast and Kansas. Don't ask me why it has anything to do with Kansas. Just is. So okay, it's all the West Coast, Oregon, Washington, California, New Mexico, I think, and Hawaii. This case goes up to the Ninth Circuit Court of Appeals. It doesn't go to the Supreme Court, so it ends at the Ninth Circuit Court of Appeals. No. Ninth Circuit Court of Appeals hands down this ruling that says you are violating the Eighth Amendment for cruel and unusual punishment by fining and threatening to jail homeless people with these camping bans. So that's basically their argument. There's a lot of other things. For a little bit more context, they relied their ruling on this older case, Robinson v. California. And this is going to be important going into the oral arguments that we're going to listen to. Robinson v. California was where they sued a man by the name of Robinson, was addicted to narcotics. So he had an addiction problem. Back then, it was a crime to be addicted to narcotics. Just having the addiction was a crime, not having it on you, not doing it or anything like that.
Approximate year?
1962.
Okay.
So for all you history buffs, you know that California was, I think it was deep red back in 1962, right? I think so. It was red up until like through Reagan in the 70s. Was it Nixon? Nixon was back then too. He was involved in California politics. You should know. You
stop.
You live near the Nixon library.
I live near the library, so I know everything about Nixon.
You should be a Nixon scholar. I'm surprised you just don't go visit it and admire all the Nixon stuff. So they relied on this case, Robinson v. California, which made it a crime to be addicted. Just addicted, not controlling, not possessing, anything like that. So they came down and said, no, you can't do that because this is an involuntary condition. Like being addicted is a disease that people suffer with and they struggle with. It's involuntary. Like you can't change that. So we can't criminalize stuff that you have really no control over. I mean, that'd be like criminalizing someone for having Tourette's. Like you can't criminalize someone for having Tourette's. It's something they have to deal with. It's involuntary. So the Ninth Circuit in this original case said, you can't criminalize the homeless because it's involuntary condition, and that's their status. Any questions thus far before I keep rambling on?
Yep.
No, makes perfect sense. Then I'm doing a pretty good job then.
I've asked questions along the way.
That's where we are. That was handed down 2018. So again, this didn't go to the Supreme Court, went to the Ninth Circuit. And when the Ninth Circuit decided it, that was the law of those states. So all those states I mentioned, California, Washington, Oregon, and Kansas, and Hawaii.
Okay, wait, is that how
they have to abide?
I'm sorry. I didn't know like that's so if that case had happened in California, it would affect all those states simply because it was the Ninth Circuit Court ruling. Like it. Okay, I didn't know that. So
yeah, so that's an important point because this case does not apply to like Texas or Florida or New York because they're different circuits. So they don't have to listen to it. It's kind of like, so when there's like Second Amendment cases that come out of the Southern District and Judge Benitez rules on them, that doesn't just affect California. It has binding effect on all these different states, including like Hawaii, Washington, Oregon, and Kansas. And I think New Mexico.
Okay.
So that's why that's where we're at right now. So since 2018, politicians have said they can't do anything about homeless. When people complain about homelessness and say, I'm tired of looking at it, I don't want encampments, like we go to the park, they're everywhere. A lot of politicians kind of like, even Gavin Newsom at one point, well, we can't do anything because of the Boise ruling. We can't do anything because the Ninth Circuit came out with this Boise ruling. So that was their excuse for all these years.
Okay.
Fast forward. We now have a similar case, almost like a carbon copy. In fact, the petitioners say it's actually a carbon copy of this old case. Same thing, Grants Pass, small Oregon town, camping ordinance ban. Homeless person sues, says you can't do that. Goes all the way up. This time it actually makes it to the Supreme Court. That's where we're at now. And that's what the Supreme Court heard oral arguments about. Now, if I can get really wonky, I actually printed off. This is the brief for the petitioners.
This is what Phil does.
I was interested. This is what I do. I love this stuff. I nerd out on it because I'm like, this is so interesting. I actually printed this off and went through and highlighted it. So for any of you who don't think we show up well prepared for podcasts and we don't have anything to do with our energy, joke's on you. I read this whole thing just for your entertainment.
How many pages is that? We can't see how many pages it is. So not that I want the exact count, but is it 20 pages, 50 pages, 250?
Just the actual petition itself is around 60 pages.
Okay.
So, but the nice thing about these petitions is the margins are really small, so you can read them really quickly.
Okay.
So it's 60 pages, but for some reason it goes by really quickly. So this is by the petitioners, and the petitioners in this case are trying to get this original case overturned by the Supreme Court. Basically, they're asking the Supreme Court to say that prior ruling by the Ninth Circuit is wrong. You should overturn it. And if they do overturn it, the result will be now all these governments can start enforcing camping bans. I mean, it doesn't mean they will, but it could. So I'm going to read a couple excerpts. We're going to listen to oral argument, and then we'll kind of break it down a little bit more. Okay. Then we're going to talk about where the heck $24 billion went, because it obviously didn't go into camping bans. Let's see. The Eighth Amendment carried forward language from the English Declaration of Rights, whose drafters recoiled at methods of torture and execution that were all too familiar to an enemies of James II, but abhorrent even to 17th century sensibilities. The framers shared their English forebears' concerns about barbarous punishments such as quartering, public dissection, and burning alive. So, also, this is one reason I love reading these, is because I'm such a history nerd that I love reading like where the Eighth Amendment came from. And side note, okay, I want to just say this for all the wannabe legal scholars on like Instagram and social media who are like, the Second Amendment doesn't mean that, like they just wrote it out of thin air. No, moron. They didn't write it out of thin air. Usually there's a precedent. It came from somewhere. Usually, actually, a lot of the amendments we have today were amendments that were already part of state charters and state constitutions. They go back way before the Bill of Rights was even ratified. There's a history. There's a reason why these amendments showed up into our Constitution. They didn't just pop out of nowhere. So that's my little rant. Do some history research. Anyway. So their whole argument is basically that the Eighth Amendment is for cruel and unusual, and this doesn't fall into it. They talk about Robinson in California. They say there the court held that the Eighth Amendment forbids criminalizing the mere status of being a drug addict while making clear that it does not bar punishments for the acts of possessing or using drugs. Given that public streets and parks have immorally been held in trust for the use of the public, governments have the power and indeed the obligation to regulate the use of public property for the health, safety, enjoyment, and general welfare of the entire citizenry. I think I agree with that. I think if you're a government and you say we're in charge of all this public area, and you as a public citizen are paying taxes to fund these parks, to clean these parks and all that, do you think the government has an obligation to regulate and make sure that park is open to everyone?
Absolutely. I mean, for safety for everyone.
I mean, safety is an issue, health and wellness. I mean, hazardous materials. I mean, we're talking about like if this is a public area that people want to go to, they want to take their kids there, they want to take their dogs there. Like the government's not upholding their end of the bargain if you're paying for public spaces and the public can't access them. So let's see. Goes on to say the Eighth Amendment does not address whether and when involuntary conduct related to status can be punished. The inability to draw principled, administrable lines has led to sweeping injunctions barring enforcement of basic laws protecting public health and safety, as well as an ever-present threat of litigation whenever a municipality tries to address the spread of encampments. All right, I'm going to skip ahead to the summary argument. I'm not going to read the whole thing. I read it just because, like I said, I'm a nerd and I love this stuff. Okay, summary of their argument. At the framing, ordinary speakers of English understood a prohibition on cruel and unusual punishments to target the infliction, imposed, and vengeance of a crime, not the crime itself. Number 2, the punishments at issue here are not cruel and unusual. Those punishments are neither cruel nor unusual in any ordinary sense of those words. For centuries, fines and imprisonment have been the default methods of punishing criminal offenses. So, again, they go into the whole definition of like cruel is obviously like you torture someone, bodily pain, traumatizing pain. That's like cruel.
Right.
Public quartering is cruel. What did they say? Like public dissection, cruel. What they did to Mel Gibson and Braveheart, cruel. Unusual would be something that's like not in use. Like it's just not usual for us to do for punishments. But fines in jail have been around forever. This court's decisions do not support the Ninth Circuit's interpretation of the Eighth Amendment. In Robinson, the court held that any punishment for the status of narcotic addiction was cruel and unusual. Next point, this court should not extend Robinson. Extending that misguided analytical approach to constitutionalize an Eighth Amendment involuntariness defense would circumvent the constraints of other doctrines such as due process. Now, I'm going to propose this hypothetical to you. And don't worry, it's not going to be like some big legalese.
You make me feel stupid again?
No, I'm not. If you can say, well, you can't criminalize me because it's involuntary, do you see if that could lead to a slippery slope in terms of crime and punishment?
Absolutely.
So, for example, would you say, like, if a pedophile is convicted of having child porn or doing something horrible, and he goes in there and says, well, I can't help it. I'm a pedophile. That's my condition. It's an involuntary act. Based on the Ninth Circuit, that to them seems like that's protection against conviction.
We're headed there. Sorry. And so, we're headed there, but it's wrong. Like,
right. So I think that's a good point that the petitioners made. That they said, if we allow this Ninth Circuit standard of involuntariness to stand, then who's to say where that goes? I mean, we can literally just have people saying, well, you can't convict me. It's an involuntary response to what I do. And that could lead to a lot of problems. So I'm going to take a break from talking because I think I've talked enough, and I need to get a sip of water because I just rambled on and babbled enough. Do you have any questions before we hop into the actual oral arguments?
I actually do have a question. And maybe you said this and I missed it, and so I apologize. But what brought about this new recent case, the grants pass? What events brought that on?
Same exact facts. Grants passed, instituted an anti-camping ban in public spaces, which again targeted homeless people. And so that's why it's like a carbon copy of Martin v. Boise. It's the same exact thing. They're being fined and threatened with punishment. So then they sued, and now they're in the Supreme Court. So, okay. So this
you did say that. Sorry.
Well, that's fine. It's a lot, and I tried to boil it down because I wasn't going to sit here and read the whole petitioner's brief or the summary argument or all that stuff.
So,
because then people would tune out and be like,
"How then?"
Please never come back from your break.
You mentioned the original case, Boise, 2018. Mm-hmm. That has now affected these other states. So, Like I mentioned when you were like in your city, the park, and I'm like, no, it doesn't happen in my city, and it doesn't. Like, I don't know, somehow homeless people, if they come here, they tend to not be here for more than a few hours. I don't know what happens.
Right.
So what then does that mean? If my city is legally not allowed to say you can't camp here, then what were they legally allowed to do that somehow moved the homeless people on from the city to wherever they went? Like, I get that we have a major homeless crisis. We talk about it all the time, and we're going to get more into it. But how is it then legally my city can be like, no, we're not doing this?
That's a good question, because the issue is that this decision by the Ninth Circuit, and again, for those who don't think I put effort into,
do you have another? Do you have another one?
The decision. This is another one, but this is the actual decision from Martin v. Boise from the Ninth Circuit that I read.
Does your wife like hear the printer going and
doesn't? She's
sorry.
Like, oh no, he's enough Supreme Court decisions now. No, so the problem with Martin v. Boise that the petitioners bring up is there's no line. There's not a clear standard of like what they can and cannot do legally. And basically, the Ninth Circuit just left it up like, well, you can't ban them if there's not enough beds and there's not enough shelters. That's cruel and unusual. Like, they just left it at that. But they didn't really give like a strong bright line test of like what's constitutional, what's not constitutional, which is another thing they bring up with the Supreme Court is right now the Ninth Circuit has kind of left us in disarray of like, well, we don't know what we can do and we don't know what we can't do. For example, like down here in San Diego,
with everything,
yeah,
they just say something, not just the Supreme Court. I'm talking about government in general. It's like they just throw something out, like with the fast food minimum wage hike, and so many companies were like, "Well, does that apply to me?" And it's like it's not written in there. Nobody knows. Figure it out. Taxes. Figure it out. We'll punish you if you're wrong, but figure it out.
Well, and to your point about how some cities get away with having bans and some cities don't, I know San Diego has recently implemented a camping ban, and it's been pretty effective, and they haven't been sued. I haven't looked into specifically why San Diego can get away with it, but you know, a lot of these cities have city attorneys, and they go to their city attorney and say, hey, we want to draft an ordinance to stop camping in public places. How do we do that in line with this Martin v. Boise case? And a lot of them probably already know, like, okay, if we draft it this way and we give them this exception and this, that, and the other thing, like, you know, that's what you pay lawyers a ton of money for, is to figure that stuff out. So they probably have their city attorneys draft up these camping bans, and then maybe they share them with other cities. But regardless, it's still not bright line enough, and like cities are not really going full force into these camping bans because they're just not sure. So that's where we're at, is that the Ninth Circuit just kind of said, no, this is cruel and unusual punishment, violates the 8th Amendment because you don't give people enough beds. So what are they supposed to do? And that's where we're at. Who should we start with? I'll let you pick. Amy Coney Barrett or Justice Sotomayor?
Sotomayor, just to be a little controversial.
Okay, we'll start with Justice Sotomayor. The liberal justices in this case went a little overboard in terms of their hypotheticals. I don't think they were completely honest. Kagan's fine, but Sotomayor I think she went a little overboard. So this is just a clip from oral arguments. Like I said, they have these oral arguments that goes on for hours. So
scope of your ordinance. So I'll ask you a question about the scope of your ordinance. So as Justice Kagan was pointing out, this criminalizes sleeping with a blanket at a minimum, right? Yeah. Correct. But as I understand it, after this decision and maybe after Martin, before that, there was some question about whether it also criminalized having fires, campfires, tents. Can you talk a little bit about that and what the scope of it is? Does the Constitution then make it impossible for a city to limit the use of fires and encampments, tents, those kinds of temporary shelters?
It really does, because the rationale of Martin, the argument that it's a biological necessity to sleep outside, the respondents argue a blanket is necessary in Oregon. Some might argue a tent and a fire is necessary in North Dakota. The Eighth Amendment really doesn't give us any answers to what cities can and can't prohibit. It's really administratively impossible for cities on the ground, as well as for courts to administer. So we're
I'm sorry, we have nothing to do with fires or tents. That was exempted under the district court's injunction, and circuit court didn't require that. We're talking only about sleeping with a blanket. Well, so let's narrow it to what it is. I agree there might be other cases in the Ninth Circuit that are not rational. And I don't mean to throw aspersions at those holdings, but some of them are not permitting time, place restrictions. Let's go beyond that. Let's go here. Here, you're not precluded from prohibiting fires. You're not precluded from prohibiting tents. What's at issue is, are you prohibited from having someone wear a blanket anywhere in the city? Your intent was to remove, stated by your mayor, intent is to remove every homeless person and give them no public space to sit down with a blanket or lay down with a blanket and fall asleep.
That's not the intent of the law, and I would like to address that point, because the other side—
Why don't you answer the basic question?
Yes. So
it's not about fires, it's not about tents, it's about not being a time and place restriction, about eliminating all choices.
So we think that it is harmful for people to be living in public spaces, on streets and in parks, whatever bedding materials, when humans are living in those conditions. We think that that's not compassionate, and that
it's not, but neither is providing them with nothing.
Well,
to alleviate that situation.
This is a difficult policy question, Justice Sotomayor. It is.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep? Are they supposed to kill themselves not sleeping?
So this is a necessity defense, as I mentioned, under Oregon law is available. States are able to address these concerns. This is a complicated policy question. We believe that the Eighth Amendment analysis, to go back to it, focuses on the low level.
What's so complicated about letting someone somewhere sleep with a blanket in the outside if they have nowhere to sleep? The laws against defecation, the laws against keeping things unsanitary around yourself, those have all been upheld. The only thing this injunction does is say you can't stop someone from sleeping in a public place without.
Okay, so that was Sotomayor saying, are you supposed to just kill yourself if you're a homeless person, based on what it's a ad absurdum argument, meaning she took it to the absurd logical conclusion that if between sleeping on a park bench with a blanket and your next step is, if you don't have that option, you should kill yourself. I mean, that's quite a leap for a Supreme Court justice to make. But again, like I said, the liberal justices on this case got a little nutty over
there
this.
There was actually a lot to unpack in that small amount of, it was a little crazy. I mean, one, don't we have
go ahead
loitering laws? Like there's already that in place, so they're breaking that law. But then just because you don't have a blanket doesn't mean you don't have a warm jacket or warm pants or socks. But then also, we have spoken on this so many times, it goes back to allowing someone to sleep out in the open anywhere isn't compassionate anyway. And fun fact that's not so fun at all about my city I forget what year it was. I want to say 2008, around there. Nobody hold me to that. We had a guy, or we found out later, this was when a man. We, like I said, we don't really have a homeless population, but we did have a few people. They were getting murdered in Yorba Linda. And like they would be sleeping, let's say, in a hallway, like a stairwell at the library. Somebody was murdered there. So this was like some sick vigilante guy, like who was killing homeless people. I want to say he killed like 3, 4, 5 people total before he was caught. Ex-military, PTSD, like lots of issues there. And that led him to believe that he needed to kill any homeless people in Yorba Linda. He ended up killing himself in prison. But I'm not saying that every city has like some sicko vigilante like this, but yet they do exist. These homeless people that were just trying to sleep in a stairwell and just sleep were murdered. That is not safe. That is not compassionate. That is not safe. That is not good for the city. And like my city has, like, that's one of the most major things that's ever happened in Yorba Linda. It's like, oh, there was that homeless killing spree. And we otherwise don't have a whole lot of crime, petty theft, whatever. But otherwise, we're like a very safe city. And that was when that happened. It was like, oh my gosh, what's going on? This is madness. But anyway, there are people like that. They're sick people.
Mm-hmm. Yeah, and that's, I think, what the petitioner was pointing out, or the attorney for the petitioners was arguing, that it's cruel to let people just sleep outside. Like it's cruel to just, unless we figure out a better solution, it's cruel to just accept that them sleeping outside, it's dangerous to them. And we want to, I think most people, we want as a society to help, but we also, we put a lot of tax dollars into, and if we get to it, I don't know if we'll actually get to it tonight, because I think we got a lot more to talk about. We might save that for another episode, why we spend $24 billion on homelessness and we haven't solved it all yet. But we spend a lot of money on homelessness in California, and there should be tons of shelters. There should be plenty of beds. There should be plenty of programs for a lot of homeless people to go to. And I think people want to help, but they also kind of want to say, like, look, we've paid a lot in taxes. We're all trying to chip in here to help, donating to local shelters as well. A lot of religious shelters, like down here, and we have Father Joe's down here in San Diego, which is probably the biggest and most popular. But we also want to give you like that nudge of like, don't sleep in the park. There's plenty of shelters. Like, we want you to go to these shelters, and so you're safe and take care of yourself. And I think that's interesting that like Sotomayor just leaves that out, that she just kind of says, well, there's no other option for them. They have to go and sleep on a park bench. In most cities, that's not always the case. And there's, I don't remember the numbers off the top of my head, but I think here in like San Diego, like the beds are never full. Like I've heard from people who work at these, they volunteer and stuff like that. They say the shelters are never at 100% capacity. So there are always beds available. And I know San Diego has put a ton of money into housing, alpha projects, and Father Joe's and all that stuff. There's tons and tons of shelter beds, and there's tons of spaces where people can go to be, whether it's like temporary shelter or something like that. So that she kind of leaves that out of it to prove her point of like, well, they have nowhere else to go, so I guess they should just kill themselves. And it's like, no, like if we're putting a lot of time and effort and tax dollars into shelters, and they're also not choosing to go to shelters, I don't know what you want us to do, because they can't just take over public spaces. So that was, it was kind of a radical argument.
I'm kind of surprised that thinking got her to the Supreme Court, to be honest. Like if AOC said that, we'd all just be like retweeting and saying all these things about how crazy and just AOC needs to go when she has no logic, and does this girl even think? We'd be like slinging that all over the place. But yeah, this is a Supreme Court judge who makes a statement like that, and you're like, really?
Yeah.
That's how you go.
Regardless of your feelings on like, there's liberal justices and there's conservative justices. Again, they're not political beings. They lean certain ways based on their interpretation of the law.
Right.
Whether you are like on the left and you hate Clarence Thomas, or you're on the right and you hate Sotomayor, Ketanji Brown Jackson. Bottom line is, all of these people are extremely qualified. Like, they are the top of their field. They went to the top law schools. Like, they are bright people.
Right.
Like, they're at any law firm, they would be named partner. They would be the top of their field wherever they are. So yeah, you're right. Like, if to hear a Supreme Court justice jump to that ridiculous conclusion sounds like a soundbite you'd hear from like AOC or like anybody on the squad, but not someone who knows how to rationalize and look at this from a purely judicial point of view. Not like, I want to score a soundbite kind of politician. So
yeah.
Should we move on to Amy Coney Barrett?
Yes.
Okay. Let's see. Pull up this one.
Follow up on that. So you're saying there are services available, there's treatment available, so people would ultimately move off the street? Is that what you're saying? Because I think part of the premise of all of this, right, is that there are not enough beds for homeless people to occupy. And so there will be a mismatch, and there are going to be some people who can't be cared for. Are you saying that if your law is enforced, there is a way for everyone to be cared for?
No, I'm saying that's a policy question that is quite difficult, but these laws are an important part of the puzzle. They're not the only solution. And we don't believe that they are, but we think they're an important tool. And without them, we've seen what's happened on our streets. We've seen that people are dying in encampments. We've seen that cities are being forced to cede all of their public spaces. So that ultimate question is for the legislature and policymakers to figure out what the right solution, what the right mix of policies is. But the wrong answer is to do what the Ninth Circuit did here and to constitute.
Let me just interrupt you there. You're right. It's a very, very difficult policy question. And I asked you before about whether this was just about blankets or whether it went into having fires or urinating and defecating outdoors and that sort of thing. And Justice Sotomayor pointed out that this particular injunction did carve out those things and was just talking about sleep. But, other cases have been litigated in the Ninth Circuit that have gone beyond that. And because the line is things that are involuntary, that are human needs, it can extend. It's difficult to draw the line. And whatever we decide here about this case is about the line. So can you describe for me some of the things that are difficult to figure out about the line? They're sleeping with blankets. What else?
Public urination and defecation, that is a serious problem. Those are parts of biological necessities of being human. A court in Sacramento addressed that, and the Ninth Circuit's opinions debated whether its rule would actually reach those things. I think any rule that we are wondering about and debating whether it would go that far, I think that is a sign that it is not a workable rule. The slippery slope here is very real. It's not just for camping and conduct that might be a biological necessity, putting aside tents and fires in cold climates. What other things would be allowed? All of the things that a human needs to survive, for example, potentially come into focus under the Ninth Circuit's rule, but also in other areas. Someone could say that my drug use or possession is the other side of the coin because I'm an addict, or because a person who it violates other laws could say that I had a compulsion to do those things that I couldn't control. And the plurality opinion in Powell addressed that very thing and why it's so important to draw the line there. And when conduct is involved, and once the court gets into deciding which conduct may be excused under the Eighth Amendment, it is so far afield of what the Eighth Amendment was ever understood to address.
Okay, speaking of status and conduct, you've argued that Robinson was wrong and we don't need to overrule it, and I agree. I don't think we should overrule Robinson. You've also been kind of resisting the status. You've been resisting characterizing anything other than the drug addiction that was at issue in Robinson as status. So what if the law said it is unlawful and punishable by 30 days in prison to have the status of homelessness? Just go with me. Just assume that the law defines homelessness as a status and it is a status. Would Robinson say that that law is unconstitutional under the Eighth Amendment? Would you concede that?
And you're saying that that is a status?
Yes, the law defines
all
it
of
as a
the-
status, and it's a status.
Well, yes, and I think it looks a lot like Robinson under that hypothetical, but of course, we disagree that it is.
I understand you disagree, but you
status
are
in that
accepting
way.
that Robinson draws a distinction between status and conduct, and you're just fighting about the definition of a status?
It draws the line where a law has no actus reus. So I think that's the easiest line. I don't defend the line under the Eighth Amendment because I don't think actually that I know the court didn't rely on any Eighth Amendment principles or
But the
history or-
hypothetical I just gave you had no actus reus either. The status of homelessness. I mean, it could be, 4:00 in the afternoon and the person is just standing outside the bus stop. Do you agree that if the law prohibited that, made that a crime, that under Robinson, whether Robinson was right or wrong, that under Robinson, that would be a violation of the Eighth Amendment?
Well, I think the better framework is due process.
I understand that. Under Robinson, do you agree that that would be wrong?
Yes.
Okay, thank you.
Okay. So, any thoughts on that one?
Can you explain that one? I have thoughts,
Okay,
but
so that's sort of, yeah, so that one got a little bit wonky. Basically, what she's grilling her about is what we talked about, which is Robinson v. California made it unconstitutional to criminalize status. Like, you're an addict, that's your status. You can't change being an addict. So Amy Coney Barrett was saying, would you want us to overturn Robinson? She says, no, I think Robinson was correct. I think it was misapplied by the Ninth Circuit in this instance when it comes to homeless encampments. So the petitioner is arguing that it also has some sort of conduct involved. So actus reus being like a purposeful action on behalf of someone to do something. So instead of a status of like, I am just always an addict, where like, it doesn't matter if I'm sleeping, I'm an addict. If I'm exercising, I'm an addict. If I'm eating dinner, I'm still an addict. Like, that's just my status in life. I'm an addict. But if you're someone who chooses to go to a public park and set up a tent in a camp and do that, like, she's saying that's where we should say, okay, that's now conduct. And we should be allowed to criminalize that or punish people and uphold these fines and these temporary jail sentences, because you've now taken an action by choosing to go and camp in these public areas. It's not your status. It's not your status of like, you're just homeless and therefore just by being alive and homeless, we can criminalize you. It's that you've decided, instead of going to a shelter, I'm going to go camp in a park or on a park bench or something. So that's where they were kind of arguing of like, where do you draw the line? Is it conduct or status? So did that sort of answer any of your questions?
that does answer my question. Yes, thank you. I felt a little off track there. Okay. I kind of thought where it was going when they brought up the man just standing outside a bus stop. He's not doing anything wrong. He's homeless, but he's not doing anything. Yeah. Why do they keep pushing this fire thing? Like, I can't imagine us just allowing all the like, oh, I get that it's cold, but like, just light a fire. That won't cause any problems at all.
I guess because that goes into like a different issue of like necessity of like, well, to survive in Oregon in the winters, you need some sort of heat source. So if they start a fire in like a garbage can or something like that, that to them is a necessity. So your defense is like, I need this to stay alive. I need this heat. So they keep talking about it. But then they also argue, well, fires are dangerous. Like, you put fires in public places. What if we light the whole thing on fire? So I think that's the whole fire. Yeah, they keep bringing up the whole fire issue of like, there's been issues of, homeless fires have, they'll either squat in like a construction site or something like that and cause a huge fire. But did you pick up on her argument that we discussed that the petitioner said, which is, if we go down this route of allowing status and saying you can't criminalize based on status, or this involuntary conduct idea, what that opens up. And that's not the point of the Eighth Amendment. So
right.
Like, that's where she's saying, if you leave this unchecked, for example, now again, a little quick lesson about federal courts and all that. The Supreme Court has to make a decision on this one way or another, right? They're going to have to say something. They're going to have to come out with a decision. That's why the Supreme Court doesn't take up every single case that comes their way. I think they get, I don't know how many cases petition to be heard in the Supreme Court. It's like tens of thousands every year. Only a handful get heard every year, maybe like less than 100. It's not a lot. But they have to understand the weight of what they're taking up will now, it's not the Ninth Circuit anymore. So whatever the Supreme Court decides will now apply across the whole country.
Right.
So it will become the law of the land once the Supreme Court decides it. So I think she's kind of leaning into that argument of like, well, if the Supreme Court says involuntary conduct can't be criminalized under the Eighth Amendment, which is a broad interpretation of what the Eighth Amendment was supposed to be, you're kind of opening the door to, like, for a lack of a better term, like chaos. Like you're now opened the door, like everybody in the world is going to cite to this case and go, I shouldn't be criminalized. I shouldn't be convicted because of involuntary conduct. That's my defense based on Grants Pass v. Johnson. I don't think the Supreme Court's going to go that way. I mean, you have six conservative justices. 5, some people say they think Roberts is kind of a swing. I don't think they're going to open it up that much. But we'll see. We'll see how they come down in terms of where they land on the status and conduct and involuntary conduct. I'm of the belief we didn't even get to the articles that I actually brought up and circled. There's a lot of stuff that
Well, and then next month is when the decision should come out. So I feel like we could do a whole.
We could do like a whole, we could do a whole follow-up on all of this. There was something else. Oh, this was another line. This is Ketanji Brown Jackson. First Justice Elena Kagan wondered, since the city would somehow ban sleeping, could it not ban another biological necessity like breathing? While Justice Ketanji Brown Jackson wondered if a city, quote, decided it was going to execute homeless people, end quote, because they were homeless. So, like I said, the liberal justices,
things got fun in there.
Yeah, they went off on these hypotheticals. But yeah, so my personal belief, if I were a betting man to say like what I think is going to happen, I think the majority is going to find that it's permissible for these camping bans, that it doesn't violate the Eighth Amendment. I think the petitioner was smart by, when you read her brief or their brief, I don't know. I don't think she wrote the whole thing. She may have just argued it. When you read the brief and they lean heavily into the history and originalism of the Eighth Amendment, they're speaking directly to the majority of the court, which is Alito, Thomas, Amy Coney Barrett, Justice Gorsuch. There's a fifth one. Why am I missing the fifth one? Alito, Thomas, Gorsuch, Kavanaugh. Yeah, those are all, they consider themselves originalists, meaning what was the intent of the founders when they wrote this and passed it? And she leaned into it heavily and said, this was the intent. The intent was cruel and unusual. Cruel is defined as drawing and quartering, horrible, disgusting stuff in public. And unusual is stuff that you wouldn't do. Like, you wouldn't be like, for today, your death sentence is we're going to drop you out of a helicopter. We've never done it before, but we're going to drop you out of a helicopter. Like, no, it has to be like a usual form of punishment. So that's my bet. My bet is they are probably going to say Martin v. Boise went too far. That wasn't the intent of the Eighth Amendment. Therefore, you can't argue under that. They'll throw out Martin v. Boise. And then we'll see how the rest of the Ninth Circuit and all these states react. Any final thoughts?
No, I mean, we didn't even get to how this applies to California, but I guess part 2 will eventually.
Yeah. Just for those who are interested in like insider baseball, regularly Camille and I will sit down and go, what topic are we going to discuss this week? And we sit there and go, do we have enough for an hour? 10 times out of 10, we end up having way too much stuff. We have, if you could see our show notes, we have like a whole nother half of the show that we were going to do. And we're just not going to get to it. So maybe that'll be another episode.
Wasted all my time researching this week.
We'll just
kidding.
Put those notes aside and save it for another episode. We'll talk about $24 billion and where it went. Maybe we can get Josh Hoover on to come on and talk about that. That would be really interesting. But anyway, so that's my final thoughts. Keep an eye on it. Next month, they're going to hand out all these decisions. The Supreme Court, what they do is they hand out all these decisions and then they get the hell out of town. Once they're done with their decisions, their session's over. They all scatter to their summer homes, wherever they are.
I don't blame them one bit. Like,
no, I mean, it was last year Roe v. Wade was overturned. So
was it
Roe v. Wade was overturned, or 2 years ago?
I thought it's, I don't know now. See, all my mental capacity is gone. I thought it was 2022, but because I feel like there was like a whole thing. It's been a year and here's what's happened. And so they were coming up on 2 years.
I'm pretty sure the decisions are already done and the Supreme Court has already left. And like they obviously issue it on there that day. I don't know who in the office actually issues it. But there's actually like a tradition of like a page like runs into the Supreme Court and like gets the decision and then they like run back out so that the reporters can get it. Like, I don't know. Traditions are fun.
Speaking of all that,
right.
No one, I mean, I'm sure they didn't even investigate, but when the Roe v. Wade decision was leaked early and no one knew who leaked it, and that was obviously a big deal. And yet here we are nearly 2 years later, and that's just, we don't even care. No one cares. It was dropped.
No one cares. Yep. Never heard anything about that. It was leaked, and Justice Roberts said they're going to look into it, and they never found out who leaked it. So I'm glad it didn't change. That was one prediction I think I got wrong, was that it might change it. But it didn't. It ended up staying true, and they stuck to their guns. So good for the Supreme Court not caving to public pressure. Actually, this is a final thought for those who are kind of want to wrap this into the whole national election of Trump v. Biden. I think Sotomayor might be on her way out. She has a lot of health issues.
Oh, okay.
There's, this is actually a pretty young court, especially with the 3 that Trump put on during his term. I don't foresee any of them stepping down. Ketanji Brown Jackson's brand new. Alito's been there a while. He's not going anywhere. But Sotomayor, I think, has health issues. Do I think she holds on for another 4 years if Trump gets elected? Probably, but who knows? Health issues can wreak havoc on people, and who knows? One day you could wake up feeling fine, and then one day you're like, nope, can't do this anymore. So for those who, to add even more gravitas to the most important election of our lifetime, as they say about every presidential election.
Every election.
It's the most important election of our lifetime.
The most dramatic season of The Bachelor ever.
It's the most dramatic season of The Bachelor ever. It's the most important election of our lifetime. It's the most highly anticipated Super Bowl of all time. But forget presidential elections. Local elections are what matter. And we urge you to go check out our shirt, californiaunderground.live. All right. So with that said, that's our show for tonight. Thanks for tuning in. I hope you appreciated the wonky legal jargon that I discussed for an hour. Anything else before we sign off for tonight?
No, just come visit us at convention. If you're a candidate, a politician, and you are going to be there, contact us. We want to talk to you live there. Yeah. If you work for a politician or a candidate, send them our way.
Yeah, California Underground at protonmail.com. Let us know so that we can try and get you a spot, because it fills up. Like we did it last time, and we literally just like set up, and it was like one after another. Like people stopped by. So if you're interested and you want to stop by and reserve a time, let us know. californiaunderground@protonmail.com. Camille will be doing a meet and greet for all of her fawning fans. So you can like take pictures. She'll sign autographs. She'll sign the back of your California Underground merch. And I'll just sit idly by and watch.
Unrelated, Camille's looking for a different podcast to join. I'm just kidding.
I know of one where you can take big breaks and like not do a podcast for like 3 or 4 months and come back. And
3 or 4 months is being generous. I think you mean like 9, 10, 12.
3 or 4 months is being generous. Try like, if you want a podcast that comes out twice a year, in 2 weeks in a row.
No, we're not. We're not doing this, Phil.
Okay. On that note,
inside jokes.
We're gonna sign off.
Don't send us hate messages.
On that note, we're back. We're going to be back to our normal schedule. We just took last week off. Back Thursday, 6 p.m. Tune in, YouTube, Rumble, all that stuff. And you can always hear us on Spotify, Google, Apple, wherever you hear audio podcasts. Make sure you like, share, subscribe, review, all this stuff for the videos. Helps us with the algorithm, especially on YouTube. And as always, the best thing you can do to support this show outside of going and checking out our wonderful new merch is just share it with a friend, family, coworker, anybody you think might be really interested in this podcast and stuff that we talk about California politics. And with that, we'll see you on the next one. Later.